Um, Second, okay. Let me first. Probably I would start with introducing myself. I'm a lecturer at the Indonesia Jenderal School of Law. It's such young law school in Indonesia, in Jakarta to be precise, and it's not a university. It's specifically uh, on law, and we aim to produce what we call as the legal reformers. So the difference between us and many other law schools and law faculties are that we um, tweaked a little bit the methodology and the way to teach law and the way to analyze law. So on that note, what I'm going to present today is one of the research projects that I've been doing. Unfortunately, I haven't published it. I mean, it's on its way, but it's not yet published. So I understand that this course is in English. So probably it is expected that the reading materials would be also in English. Unfortunately, the short articles in the form of opinion in the media, I mostly wrote in Bahasa Indonesia and Indonesian language. But anyway, I will give a number of those op-eds to the organizer. So if any of you wants to make use of them, please by all means. So my session is about authoritarianism and legal power, the use of law to increase political control. I use this PowerPoint just as the guidance for our discussion, but please bear in mind that many of the stories, many of my analysis will be explained verbally. So please do not only rely on the PowerPoint material. I should start with the big question. I think this is like a very basis of our discussion today. Why legal power? Why do we have to talk about legal power in order to increase political control? Let me first trigger our discussion to talk again about the coercive power of law, especially the legitimacy of law, and more specifically, let me use Indonesia as a good example. In a way, it's good, especially in the form of analysis, but obviously it has very bad impact on the society. That in the Indonesian context, the obedience to the state is seriously highlighted. So probably similar in countries that are prone to authoritarianism. Civic education, for example, in schools, formal schools, and even universities are actually designed to create this patriotism's uh, narrow patriotism and narrow nationalism approach to understand the relationship between the state and the society. So what's highlighted in the civics education is mostly about the obedience to the state. And in the legal context, then we can also see that the obedience to the state will be represented in the obedience to law. So being a good citizen is being a very obedient citizen to the state law. That's basically the basic idea of how civics education is generally in Indonesia. Of course, I'm generalizing. I know that there are also a number of lecturers and teachers who try to be critical and introduce critical thinking to their pupils, but generally that's the message. So so I would say that Indonesian society is a good a ground, fertile ground for planting the idea of the uh, strong obedient to law. And the problem is then that one of the central features associated with law is its coerciveness. And by coerciveness, I mean is that it has strong legitimacy to be to be obeyed by all citizens without question. As you all know, that even in terms of jurisprudence, we also have the principle of or the theory of um, the fiction of law that basically supports the idea that once a law is published, then nobody can say that they don't understand the law, they don't want to obey the law. That principle is important to guard the coerciveness of law in ideal state and ideal society. That will be perfect, because the philosophy of law is to regulate the country. But the problem is when the obedience of law is used um, so that the society would not question anything about the law, even if the law is apparently not just, then that's really the big hole that will let us discuss how actually law is used for political purposes. And the problem, I don't know in any other countries, because I saw that in the list of participants, there are also people from different countries. But in Indonesia, for example, we, especially people who don't study law, would have um, challenges in understanding what law is. So let me start with that, and why in Indonesian context it's important, because the translation, quote unquote, of law in Bahasa Indonesia in the Indonesian language is hukum. So I put my expression then that we have lost in translation in Bahasa Indonesia, because then we would assume that law is regulation. So my criticism against my own background is that in the Indonesian context, then we we could very much how do you call it? I wanted to say the word ridicule, but I think it's too harsh on that. But we would make jokes that bachelors of law is actually bachelors of regulation, not really law. So law is understood generally by many Indonesians, and that's actually related to how we study law, um, as regulations only. Very few people understand the meaning of the court decisions. And let's start with the fact that indeed law is one of the features of law is regulations. But we also then have to talk about court decisions. So when we talk about law, then we have to talk about lawmaking institutions and law enforcement agencies. We have to touch these two um, areas of law, the making itself and then the enforcement, because enforcement is not only in the criminal justice system, but please do not forget that actually lawmaking process also happens in the court. We have in Indonesian context again, uh, constitutional court that review laws via the constitution, and we also have um, precedents that are um, regulated by the Supreme Court of the Republic of Indonesia to determine which ones are the findings of law through court decisions by the judges. So let me now talk about authoritarianism and constitutional law, because uh, the the very area that will touch the issue of how law is used for political purposes is constitutional law, and we should, in my opinion, first of all deconstruct what democracy is. And democracy is about accountability. So when we want to distinguish the difference between democracy and authoritarianism, actually we have to deconstruct first what defines democracy. and we tend to define democracy as, in institutionalist approach. We will we tend to see democracy as formal institutions such as the parliament, the court, and the executive, and all that, which is also true. But in essence, in principle, democracy is about accountability. So when we are asked what's the difference between democracy and authoritarianism, actually that's the key. That in an autocratic regime there is no checks, there is no accountability. The institutions, and let me also highlight that whenever I say institutions, please do not translate it in Indonesian language again. Institutions is not only about agencies, but it's also about procedures and everything, in the literature of institutionalist approach. And the second thing I want to discuss in this slide is about competitive authoritarianism. One of the literatures, the prominent one, is the one by Levitsky and Wei. Since 2002, they already talk about competitive authoritarianism, or we can also call it hybrid regime. If we use the framework, for example, probably it will be a little bit easier if we use the visualization of the democracy index from the Economist Intelligence Unit. Let me go there a little bit because I think here it is. So if we just use this democracy index because it has a visualization and it has a number of categories on um, how to put a country under these four categories, then we can see where the hybrid regime is, what is meant by Levitsky, for example. As you can see, Indonesia is in the flawed democracy category, falls in the flawed democracy categories. The score of Indonesia this year, I haven't seen. It should be out actually, because I know from the Transparency International that um, a number of indexes are out already for this year because this is already February. But let me just use this not for the score for Indonesia, but for the categories and for the parameters that are used by the Economist Intelligence Unit. Here we can see that the highest rank are labeled as full democracy, and the second tier is flawed democracy, but the third one is hybrid regime, and the fourth one is authoritarian. So hybrid is when you can see still a number of features of democratic country in those countries. But in essence, it actually doesn't have accountability. And then we can see on the right hand side of the slide about the parameters. We can see there, first of all, it's electoral process and pluralism. And secondly, functioning of government, and then political participation. I'm only reading it out loud from the right hand side of my slide. And then political culture and civil liberties. So these are the ones that I mentioned, I termed before as accountability. So democracy is not only about the institution, but how the institution works or doesn't work. So in Indonesia, again, for example, Indonesia has those institutions basically are working. So when we talk about functioning of government, yes, Indonesian government is functioning. But the critical question is, for whom are they functioning? For whose purpose? Is it for the society at large, or is it for the elite of the society and for the oligarchs who actually run this country? So that's why it's really it's really difficult. Actually, it's really challenging. I can say difficult. It's challenging to value democracy in the country, and law is something that can hide those facts, because the tendency is whatever is legal, we can easily then call it as correct, as if whatever legal and issued by the government um, is already just, is already democratic, because it's the result of the legitimate government. But the fact is, they're not, because the government itself is hijacked and used for other purposes than the society. Now, let me go back to the slide where I was. So, when Levitsky and Wei in 2002 talk about competitive authoritarianism, what they are trying to say is exactly how hybrid regime is. So they appear as if they are democratic because there is a degree of competitiveness, but the competitiveness is only an illusion, because among the democratic institutions themselves, actually, they don't have accountability among them and also to the people. Now, the problem is law has the legitimacy to control, as we discussed before, right? So, because the law has the legitimacy to control, then it's relatively easy then to produce law um, that only justify the wrongdoings of the government in terms of democracy. So if the $6 million question is then how, and again we can look at the interplay of politics and law. Um, if we see the philosophy of law literature, we can see clearly how law can easily be used for political purposes. Law can also be a tool for ideological purposes. If you read a number of uh, articles and books, for example, on Marxism theories, on how the law as the forum for ideology, for example, where you can see um, the debate between different classes in the lawmaking process, then we can actually fully understand that. That's why I will actually propose for many um, students of law to to study law in using the framework of political economy, because then we can also see, for example, law for for economic purposes. And one of the literature that you can explore is law and development. I studied especially on law and development for my master's degree, and using law and development theories, for example, we can see how um, in the when when the government purposes is purely development, when their achievement is measured only by economic growth. I studied that actually for the Suharto era as my case study. I didn't expect that this year I can see the same thing for Jokowi and Prabowo governments. That, for example, the current Indonesian President Prabowo put already in his vision and mission, political mission, economic growth of 8%. There's nothing wrong with that. But the problem is there's a basic criticism on how we actually measure growth, economic growth. 8% is really high, but apart from, we can always debate on which one is too high, which one is too low, and etc. But fundamentally, the problem is that when we only use economic growth as the measurement, when we only use the GDP as the measurement, then we tend to disregard the human development aspects of growth. So we will only measure the aggregate of the economic benefit. We will only measure the big businesses and how the trade between countries, especially Indonesia trade with other countries in the world. We will not see, for example, how that um, measurement is reached. We cannot see, for example, how many people are um, coercively removed from their own lands. We don't analyze anymore what the impact of development to the environment and the society, because in the head of the lawmakers is economic growth. And what's the relationship between this and the law? And then we can see that laws will be produced only to justify those actions, to forcibly remove a number of indigenous people, for example, for big companies to take over their land for mining, or for um, big plantations. That's just one example. But in the Indonesian context, again, we can see a number of laws made for that purpose exactly. One of the biggest law for that purpose, for economic purposes, is the job creation law. For those who don't study Indonesian law in depth, can look for uh, the literature on that, the job creation law. In um, 2021, we have this omnibus law. Uh, the title is nice, job creation. But if we see, if we analyze it in depth, then we can see that because it's an omnibus law, so it has a big number of laws actually changed in that one particular law. To be precise, there are 78 laws amended partially in that one, the omnibus law of the job creation. And the sole purpose of those changes is to um, have the business environment to attract investment. But the critical question is, at what cost do we invite investors? Because then if we analyze one by one example would be actually the greenwashing of the oil. I mean, how do you call it? Uh, a number of plantations. That's Article 110A, if I'm not mistaken. But because I just discussed it just now. So that's one example where a number of big plantations, although they actually took state land for their plantations, they can their sins are going to be washed using that particular law, so that they don't get sanctioned. Instead, they only pay fine. And in the corrupt country like Indonesia, then the fine and this will be a big case. Actually, it's already started. The investigation started already by the Attorney General's office. The problem is then the fine apparently goes not to the state, but to the pockets of a number of public officials, because they had negotiations with the plantation owners, so they can reduce the number of fine that they have to pay, but the money actually goes not to the state budget, but to the pockets of a number of public officials. So that's just one example. I'm sorry if I'm going too detailed, because everything is just fresh because I just discussed that. But that's really exemplifies how law is used for economic purposes. And by the same token, we can see also how law is used for political purposes. So, to put it more clearly, then the how question can be easily answered by saying that the lawmaking processes and the law enforcement processes, they are hijacked for the political purposes. Now, in terms of the legal discourse, one uh, one body of literature that I can put on the table so we can discuss later on is autocratic legalism. So, ladies and gentlemen, participants, actually, this is something that you can easily look for because there's even a blog for that by Kim Lane Chappell and her colleagues about autocratic legalism in many countries. So, um, so I'm doing a research actually to fill in how is it in Indonesia. So just to put it, I don't want to rephrase the framework, but let me just screenshot what Kim Chappell actually wrote about this. So basically, just to make it a little bit probably easier to see, is that in autocratic legalism, we would see how you can read in front, yeah. So the autocratic legalist um, will use law basically to hide a number of actions to, I would say, uh, um, to ruin the democracy. I mean, in other terms, before I came to this term, I use more the political term for this. For example, by Nancy Bermeo, who wrote about democratic backsliding. And then Levitsky also, there's one book that is very well known in Indonesia about how democracies die. Um, those are in political terms, but let me put it in legal terms. So the features will be similar, or I would say actually the same. But let's put it in the spectacle of legal study that undemocratic practices are hidden behind law and its legitimacy. So let us use Indonesia as the case study. What I see as the indications of autocratic legalism is fourfold. One is the hijacking of the House of Representatives, and the second one is the hijacking of Anti-Corruption Commission, and the third one is court capture, and the fourth one is the weakening of civil society, or we can find easily the literature in terms of the shrinking civic space. Now, let me explain to you just briefly one by one. House of Representatives, for example. The case of Indonesia is interesting because of the political system and the general election. Um, Currently, the House of Representatives Indonesia has 8 political party groups, or we can call it fraction, or in Bahasa Indonesia, fraksi. But probably in the more probably in the English term, the correct one is the political party groups. We have 8 parties in the parliament, in the House of Representatives. Now, Indonesia applies a presidential system whereby uh, the well, I should first explain that the presidential system, when presidential Indonesia applies presidential system, but the political party system is multi-party. So it's a mixture of presidential system in the multi-party context. So the literature from Juan Lins, for example, can be used in this context. As Juan Lins put it, if we put presidential system in the context of multi-party, then there is the tendency for the president to create coalition, although it's a presidential system. Now, the problem in Indonesia is that the political culture is not well developed, and most of the political parties, if I cannot say all of the political parties, are only about searching for power and money. Again, using political economic analysis. So the result of the presidential system in the multi-party context, in the underdeveloped political culture, is that Indonesia now has a House of Representatives without the opposition, without formal checks from the members of the House of Representatives themselves. So basically, 7.5 parties in the parliament uh, are the member of the coalition of the Prabowo government. Probably Indonesian participants will question the my language because I use 7.5. Because I will say that PDIP, that's the Indonesian Democratic Party struggle, um, still has two factions within the party. One is the one who supports Prabowo government, but the other one is the one who still wants to be critical towards the government. But I should add that that second faction that I just mentioned is actually weakening because now uh, you see this is the use of law because now the Secretary General of the party is just taken by the law enforcement agency for um, a criminal case. I won't say that he is innocent. No, he also has indeed legal problems. But then we can also be very critical to ask that why now? Why after 5 years of the first case appeared? The case, for those of you who didn't pay much attention to the case or who are not in the Indonesian context, I apologize for that. Let me then explain a little bit to you that the case started actually in 2020. But that particular party was in power because that was the party where President Joko Widodo, ran for the presidency in 2014, the beginning of the first term of Joko Widodo. So they were safe for the rest of, until the end of Joko Widodo's term. But now, when they still refuse to fully cooperate with the government, after 5 years, they took the Secretary General. So basically, there's no opposition power in Indonesian parliament. And but this is not the first time. Actually, during Joko Widodo presidency, the coalition of Joko Widodo was also very big. Of 9 parties in the parliament, only 2 parties are in opposition, supposedly in Joko Widodo's administration. So that's why I mentioned before the omnibus law and job creation that was passed during Joko Widodo without any objection, or there were little objections, but it's very insignificant, so the law can easily be passed. And so that's how the system is really prone to be hijacked because of the political system and because of how political parties operate and the lack of ideology in the political parties in Indonesia. So that's one, and that's also because the House of Representatives, I would say, is hijacked even since Joko Widodo's administration. Then the number second of my analysis, the Anti-Corruption Commission, can be done easily in 2019. So just briefly, the Anti-Corruption Commission, or KPK, um, is an independent body, probably very similar to the one in Hong Kong. Uh, it is an independent body, or it used to be an independent body. So let us see the KPK as also a law enforcement agency. It was effective, and that's why it was killed, because it was too effective for a number of people. Um, and now it is used as political tools. There are also analysis on this, how the KPK or the Anti-Corruption Commission was hijacked actually effectively to be used as the tool to use or to threat a number of political actors using corruption using corruption procedures. And that was pretty effective in the last year's election. That's one example, including the one for the regional leaders election that uh, that was conducted in November last year, 2024. That was pretty effective. And as also you can see in my story previously about the Secretary General of the Indonesian Democratic Struggle, he was also detained by the hijacked Anti-Corruption Commission. Again, I'm not saying that he is purely innocent, but we can clearly see how um, anti-corruption law and other types of law are easily used when the law enforcement agencies are just tools for political actors. We can see it again later on in the fourth analysis that I made. But let us go to the third analysis, which is the court capture. And the biggest example of this is when in 2023, the um, Constitutional Court, who is responsible for checking the constitutionality of the law, um, in the end of 2023, Joko Widodo actually used their power to make way for his son to run for vice presidency. And he was succeeded, as you know. Joko Widodo's son, Gibran Rakabuming, is now Indonesia's vice president, together with Prabowo as the president. But that's an example of court capture. Of course, there was already sanction for the uncle of Gibran Rakabuming, or the brother-in-law of Joko Widodo, Chief Justice, former Chief Justice Anwar Usman, that's his name. But let's analyze that beyond that particular decision to make way for Gibran Rakabuming. That is to capture the court systematically. There were 3 attempts. One succeeded, one failed, and one is underway. The one that is succeeded is when they actually replaced a constitutional court judge. His name is Aswanto, by another constitutional justice, and his name is Guntur Hamzah. Now, let's put it in the context of the independence of the judiciary, that in the universal principle that we all apply. So it's not particular in Indonesia, or it's not particularly in Asia, but this is a global principle on the independence of the judiciary, the very basic principle on the and on the principle of rule of law and democracy, that a court cannot be threatened using the tenure of the judges. But that's exactly what happened. So that one particular judge is replaced. That happens already in 2022, if I'm not mistaken. Uh, the, but we are not only defending that particular judge. We are not defending Justice Aswanto. What we are defending is the effect of that replacement that actually threats the independence of the judiciary as a whole. So that was a successful attempt, unfortunately. And at that time, a number of constitutional law scholars, including myself, already actually came to Joko Widodo as the president at that time to stop the inauguration of that particular law, because that's actually unconstitutional, illegal. But apparently then we understand that Joko Widodo himself actually gave his blessing to the replacement, because then that also has positive impact for him and his son to go for the vice presidency. Now the second attempt is the attempt to change the law on constitutional court. Luckily, it's failed, yeah, because in the law, basically, the laws wanted to be changed, wanted to be revised because they want to easily again threat the constitutional law justices to replace them at any time they want, which is again against the principle of the independence of the judiciary in terms of the tenure. But then again, in Indonesia, not many people pay attention to the principles. Not many people pay attention to the ethics and values, especially constitutional values. What's important for many Indonesians is whether there are articles on that or not, whether they are legal or not. Although then exactly what is proven in the autocratic legalism analysis is that those legality, the legalism is actually used to hide the undemocratic practices. Now that's the second one, but the third attempt, which is so far actually succeeded, is when the parliament, the House of Representatives in Indonesia, issued their own regulation, their own. So it's not even a statute; it's a law um, that says that they can recall anyone who they're appointed, who they appointed public as public officials. So of course, as the House of Representatives, as the Parliament, they have the power um, of confirming a number of public officials, judges, for example, and then the governor of the Indonesian Central Bank, and then the commissioners of Anti-Corruption Commission, you name it. Basically, almost all public officials are to be confirmed by the House of Representatives in the Indonesian context. Probably it's similar to how Supreme Court justices in America, in the U.S., I mean in the United States, uh, have to be confirmed by the Senate. Here in Indonesia, it's by the House of Representatives. So the third attempt is now successful because it's only a parliament internal regulation. It is unconstitutional, but the process was successful because we cannot touch up on that particular regulation because it's an internal regulation. So efforts are underway to challenge that particular regulation because that's actually the attempt to capture the court. But the fourth indication of autocratic legalism is the weakening of civil society. And one of the tools to weaken the civil society is, again, the law, regulations, and the law enforcement agencies. To be precise, by using laws such as the information ITE law is a law on the electronic transaction and information. That's the formal title of the law. But there's one particular article in the law that is easily interpreted to threat anyone who use social media in whatever forms to criticize the government. There are a number of activists who actually went to court um, because of that particular provision in the law. And there are also many other laws. One example is a punk band. Just very recently, the group is called Sukatani. Oh, my 25 minutes almost over. 45 minutes. I put the alarm for myself, so we have more time for discussion. So anyway, Sukatani band. Uh, um, the in Indonesian we call them oknum. So a number of officials who don't like that the band actually made a very popular song. Now it became more popular because of what they experienced. criticizing the police. Basically, it says, yeah, whenever whatever we have to do, even to report anything to the police, we have to pay them. So it's called bayar, 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 pay, 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 or bribe, bribe, bribe. So that's the song. That's what the song about. But then again, the police use their power, saying that, oh, we only visited them in terms of in restorative justice. So we told them that they shouldn't do this, because then you can go to court. Let's just, stop singing that particular song so that you won't go to court. They call it restorative justice, although it's not. But that's exactly a good example in a way, um, on how legal terms, legal or law enforcement agencies and regulations are used to threaten the civil society. So even they're not too critical of the government. So all of those with the framework of that law is about political configuration that affects the lawmaking process, and law is about law enforcement agencies, and law is also about public perception. I'm sorry, public perception and the legitimacy of law. Then, as Kim Lane Chappelle put it, the new autocrats, just see the ones that I highlighted. The new autocrats come to power not with bullets, but with laws. They attack the institutions of liberal constitutionalism with constitutional amendments at the end of the day. That's the how the story is, because Kim Lane Chappelle described it in the context of Hungary, and Javier Corrales. Actually, Javier Corrales did that earlier in the context of Venezuela. Um, so further, Chappelle said that they carefully preserved the shell of the prior liberal state, the same institutions, the same ceremonies, an overall appearance of right protection, but in the meantime, they hollow out its moral core. They took the moral core. The source of the, philosophically, as we all know, the source of legitimacy of the law is morality, but they took out the morality. So then Chappelle poses a how do you call it? It's like rhetoric question. How many people can really see this until they themselves need constitutional protection and find themselves defenseless? By then, it is too late. So I think many of Indonesian legal scholars and many Indonesian, political scientists just realized it probably around last year when Joko Widodo finally, I would say, took off his mask, revealing his true self by proposing his own son for the vice president. So let me close this presentation because it's already almost 50 minutes now. That again, I use this because this is such a good illustration, just for the purpose of illustration. I'm very critical about indexes, but let's just use this as the for illustration and to see what is actually democracy and how law can easily be used to tweak democracy from its true self into something that is actually not democracy. And law can easily be used to hide those facts because law has the legitimacy, law has power, especially in the countries like Indonesia, where a good citizen is law-abiding citizen. Then whenever um, the corrupt government use law, make even law for themselves to hide their agenda, then as if there's nothing wrong. So one can easily say there's nothing wrong with Indonesian democracy because everything is, tidy in terms of the arrangement of law. We still have the police functioning. We still have uh, laws produced by the House of Representatives and the President. We have everything, even we have the obesity of regulations in the Indonesian context. But the real question is, for for whose purpose is the law made and enforced? So law is indeed a good cover up for the whole story of ruining the whole democratic processes. So by that, I end my presentation, and I'm very happy if we can have more discussion on this later on. So I'm giving back the forum to the moderator. Thank you very much.
Okay, thank you very much, Ms. B. Fitri, for giving us such an informative and interesting presentation about authoritarianism and legal power, the use of law to increase political control. Okay, so ladies and gentlemen, now let's move to the question and answer session. Please type your question into the chat box, or you can use the raise hand feature to ask the question directly to Ms. B. Fitri.
Any questions?
Okay, we still wait
I
for the question, yeah, Ms. B. Fitri.
Okay. No, because yeah, well, I hope my presentation is not that confusing, so nobody has the any question. Let me interpret that positively, that my presentation was too clear, so nobody has the criticism. But please also share whatever thoughts you have, even experience, right, Giza? We can you can also disagree with me.
Yeah. Oh, we have one here. Do you want me to read it for you, or you want to read it by yourself?
I can read it myself,
Okay.
but so other participants can also know the question. Can you tell us more about your opinion on Indonesia Gelap that lately happens in Indonesia? Okay, Indonesia Gelap. So for those who are not Indonesians, let me just briefly explain that it's a big hashtag, if you may, hashtag or the movement label for the currently we have big movement about the dark Indonesia. Well, my opinion is that it's uh, something that is supposed to happen at this moment, because exactly I'm taking it, back to the core issue of this session, right? So it's really so we also maintain the coherence of this training or discourse, that the use of law to mask the undemocratic practices um, is really perfect to hide the dark side of how the country is run. So this is not only happening in the Joko Widodo's administration, but also in Prabowo's administration, which is now. So during 100 days of his presidency, we can already see his laws and policies that are not made using good governance principles. Let me just use one example. Why the dark Indonesia is something that we, I think, have to participate in these days. One example about how to use law. Probably we all know that just a week ago we have new law on mining. So that's the second revision of the mining law, and there was a big news about how the lawmakers actually want to grant the priority to get um, mining concession to universities, which actually many seen as the way of the government to quote unquote buy the loyalty of universities, especially scholars. Okay, that was taken out. they say. But if you see clearly, I have read the revised law. If you see clearly, it actually still has priorities on a number of institutions, including small and medium enterprises and universities. So it is still there, but in different forms, in different wordings. Uh, and even more than that, we all know since last year that the mining concession is also given to the religious-based organizations. That was actually wrong. That there are many arguments on that, but the government regulation on that was already out. Actually, a number of colleagues, including myself, actually went to court to challenge that particular government regulation because it's against the mining law. But instead of correcting the government regulations, they instead changed the law so that the law now actually justifies the government regulations. So this is how the practices of lawmaking lately. That's just one example. Another example is also the new law. I just got the copy of the how do you call it, law that is already given the number. Yeah, so it's now law number 1 of 2025 about the state-owned companies that basically give way to the establishment of Danantara. That's one big holding company for all state-owned enterprises in Indonesia. Many economists have pointed out how the the danger of such business vehicle. But let us focus on the law procedure. That those two laws that I mentioned, just as examples, the state-owned company law and the mining law, both are made both were made in the process that are totally disregard participation processes, totally disregard transparency principles. For what purpose? Just to justify what the government wants. So, so those are only two examples. But even before that, we talk about the increase of the how do you call it, the tax, yeah, value added tax in January 2025. And then we can talk about budget cuts. The government terms it as efficiency, but I refuse to use the term or the label efficiency because there is still some good connotation on that. In my opinion, it's purely budget cut. And the budget cut affects all sectors, including education and health services. So now many more Indonesians are affected by the actions of the government. And the problem is as if there is nothing wrong with those actions because they're all easily, packaged as law, whether in terms of the statutes made by the House of Representatives and the President, or by government regulations, or by any other, regulations. So as if they are legal, they are not fundamentally wrong. So yeah, so the Indonesia gelap or the dark Indonesia reflects actually the phenomenon that is that we can see lately in terms of how our country is run nowadays. Okay, should we continue, Giza? There's the
Yeah,
second question.
yeah, there's another question here.
The question is the future of Indonesia's legal system under the new president's administration, considering that in less than a year, he has already utilized the law in alignment with his personal interest. Well, as the hashtag goes, Dark Indonesia, actually, my opinion is that we also have dark future in terms of the legal system. The problem is that most of the time we see legal system, just as legality. But the problem is that legal system also reflects the certainty of law in this country, and that will also affect, investment, foreign investment, foreign, basically the place of Indonesia in the global context. And I see a dark future. What I'm saying is like I'm ini ya, as if I have like the power to see the future. But let's analyze this. And the fact is that law is used by, you're right, Rose, that law is used to cover personal interests of the elite. So I wouldn't say this is all about Prabowo, but also people around Prabowo and the businesses around Prabowo. So we are not talking only about one person. We have to talk about Jokowi and then Prabowo, but because law is made use by those circle, by those elites, now everybody can make use of law as long as they have power and as long as they have money. So this is like a wild west gitu ya. It's like wild forest, in a way that there is uh, the hierarchy that based upon the power, our power in terms of political power and economic power. So, and then I should also, I think, and when we talk about the future of Indonesia's legal system, I would also mention the need to reform the police and also the Attorney General's office. So when we talk about the legal system, again, we must also talk about the law enforcement agencies besides the lawmaking processes. So the law enforcement agencies and the avant-garde of the law enforcement agencies is the police. And so because the police will, interact directly with the justice seekers, i.e., ordinary people, and and the police has this um, uh, symbiosis mutualism kind of relationship with the political actors. So they make use of each other between the political actors and the police force as law enforcement agencies. That's why recently in Indonesia we have this saying that the police is like partai coklat, brown party, because the uniform of Indonesian police is brown, coklat in Indonesian language. Because we can see that the police has been acting as if they are their own party uh, because then they can rule, they can shape the political sphere in Indonesia, and that is apparent from the election process in February last year for the presidency and the legislative, and also in November last year for the head of the local governments. So a number of activists and scholars like myself has been pushing to, the reform agenda of the law enforcement agencies. So that's why we are now pushing for the revision of the criminal law procedures. We call it in Indonesian language KUHAP, Kitab Undang-Undang Hukum Acara Pidana, criminal law procedures that will have proper, I would say proper, because it's how it should be, proper checks on the power of the police. But instead of prioritizing the law, now the police put their agenda ahead, which is to revise the law on the police force for them to have more power in the society. And again, because of the symbiosis mutualism kind of relationship between political actors and the police, then the political actors, happily open up the way for the police to, um, you know, to put their agenda first, and put the agenda of the criminal law procedure revision later. So that's one of the challenges that I think exemplify why I believe that it's also a dark future for Indonesian legal system. And then um, aku lanjut ya, Mbak Giza. I can continue, right? There's a
Yeah.
there's also a question about the difference between rule of law in democratic states and rule by law in authoritarian regime. Thank you. This is a very interesting question. I can show you one interesting, just one slide. Don't worry that it won't be for another 45 minutes. But there's one slide that probably can help us to understand rule by law and rule of law. And it's a book by Brian Tamanaha. And let me just pull out one of my slides that I use for one of my lectures. It's readily available, so it should be taking too long. I just need these. Wait a second. I just need this. Here it is. Um, I because it's also in English in a way. I mean, I just put the title in Bahasa Indonesia, category rule of law, categories of rule of law. But I quote Tamanaha as is, yeah, because I put even the explanation that he put in his book, I reproduce it in my slide. So as you can see, let's use his framework to understand more. So Tamanaha divides or categorize rule of law in 6 stages. And the 6 stages he put again in 2 versions, the formal versions and the substantive versions. And then we can see the thinner one going towards a thicker one. And then he put number 1, 2, 3, 4, 5, 6. So a rule by law in the authoritarian regime can be seen as only the formal version because they authoritarian government will just use law as the instrument of government action. A little bit better government will also use law, but at least they have a generally prospective, clear and certain. And then already thicker, number 3, already thicker, but still actually in the formal version category, which has democracy and legality. So it's good enough, but only in the formal way. But a better one is obviously on the second row, the substantive.
Iki sih kanannya siapa?
Boleh di
Pipip.
boleh di mute. Ada yang bocor suaranya, maaf, bahasa Indonesia.
Gak tahu ini.
Halo.
Pipip.
I'm sorry. Okay. Probably the organizer can help me to mute the participant. The substantive version is better, obviously. Number 4, as you can see, it has substantive version of rule of law, which is human rights. In my reflection of the rule of law is that despite all the categories, like the DIC, for example, AV DIC, the one that usually is quoted by many of legal scholars, will talk about the supremacy of law, yeah, right, and equality before the law, constitutional based on human rights. But my general reflection of the rule of law is that the rule of law has to be based on 2 main principles. One is human rights, and the second is the limitation of power. So in that sense, Tamanaha then poses that the substantive version of the rule of law, first of all, has to capture the human rights. But the thinner version, number 4, only captures individual rights. The better version, number 5, the government will already capture rights of dignity or justice. So this is more This is a thicker understanding of human rights. A better one would include social welfare, substantive equality, and all that in terms of human rights. So it's the thickest version, number 6 in Tamanaha's term. So yeah, so back to the question that the question was again the difference between rule of law and rule by law. Again, in authoritarian regime, law is used only to hide undemocratic processes, whereas rule of law in democratic states, please use law, please understand or please grasp law not only in terms of formal regulations, not only in terms of provisions in the statutes, but more generally, justice itself. Next one by Arfandi. What are the main factors causing increasing public dissatisfaction with political institutions in weakening democracies? Main factors causing increasing public dissatisfaction. Let me first of all underline the term public dissatisfaction, meaning public perception. Public perception can be shaped, in my opinion, um, by something that affects the public directly, such as economic pressure. So I would say that's why the Dark Indonesia movement is getting bigger, because the policies nowadays directly affects many ordinary people in Indonesia. Many new unemployment people. There are businesses that are dying because of the budget cuts and other criticisms. But the secondly, and we have to be critical about that, is um, fabricated perception that can be done using the power of social media and mass media, also using populist kind of policies. So I would say that about 2 years ago, it was still very challenging when we, especially myself, talk about democratic regression. Although, as we all know, in terms of academic literature, there are already books on the democratic regression. I mean, even the conference at the ANU on Indonesia updates already since 2017 already talk about democratic regression. And at that time, we already mentioned, how democracies fail book by Levitsky and Ziblatt. We already talked about many. I mean, our circle, academic skills circle already started to talk about it. But general public in Indonesia 2 years ago still was still didn't get the idea of how weak our democracy is. Only when Joko Widodo was very brutal in using his or in misusing his power in the last election, that many eyes of ordinary people opened. So Jokowi is not the god anymore. But even more, to go back to my point about the perception that is shaped by direct effect to us, is the economy. So, so the main factor, I think, causing the increasing public dissatisfaction is when they clearly can finally realize and feel themselves, experience themselves how the political decisions made by our politicians actually affect their livelihood. So I think that's the main factor. And then by Rozan Muhammad, uh, in what ways does competitive authoritarianism maintain the illusion of democracy? And how can civil society effectively challenge legal mechanisms used to suppress political opposition and human rights? Very interesting and important question. Thank you. So, in what way competitive authoritarianism maintain the illusion of democracy? I like the term, the illusion of democracy. It maintains the illusion of democracy by still showing the competitiveness of political actors in our democratic setting. So, and it was done by having, for example, still the general election. So, we are um, delusion uh, about delusional about having democracy by having still general elections. Last year we even had two democratic elections, and we can still say that it is democratic because there's also a court procedure to challenge the result that was just ended a couple of days ago. There is this election commission, but actually in essence, in principle, we know that the votes are mostly obtained by using money politics, by distributing envelopes to voters, or by bribing uh, a number of oknum or people inside the General Election Commission, so that they can win the votes, they can gain the votes. So that's how competitive authoritarianism cover up undemocratic practices by still having the institution, by still having the procedures, but essentially it's not for democracy itself, but for uh, just to get power for a small number of elites. And how can civil society effectively challenge the legal mechanism? By using a number of ways. One is by using counter narrative. Uh, I we can discuss this further probably in other occasions, but using narrative, counter narrative in campaign, in social media, in offline discussions, probably discussions in the kampung-kampung, yeah. We still need that. We need that type of social movement type of activities. So I'm saying social movement in terms of literature like from Tilly, McAdams, yeah, in early 2000 they coined theories on social movements, and it's an important process that social movement is not only about a number of demonstrations, but it's about um, having constant um, criticism and more people who are more um, uh, critical in looking at how the country is run. So that's one example, counter narrative. And secondly, to challenge that in the legal forum as well, not only for survival purposes, like what we had to do when we had to defend Fathia and Haris at that time. Probably most of you remember how the ITE law was used against Fathia and Haris, two activists from the human rights organizations, because they criticized one of our powerful public officials. But not only in terms of survival, we have to actively challenge that in court. And one example is that a number of groups led by the Legal Aid Foundation, for example, actually went to the Constitutional Court to challenge part of the criminal code that frame um, basically that frame hate speech and is used by many legal law enforcement agencies against activists. So that's the second way to use the legal forums itself, such as courts. And secondly is policy advocacy. And this is done by having more and more discussion, substantive discussion on the related stakeholders, such as judges themselves. We did meetings with younger and progressive judges, to talk more about the essence of freedom of speech, so they understand that this is not supposed to be done in democratic country. And then we had also meetings with a number of public officials and who have, some degree of influence in the policy making. So the three ways of advocacy have to be done, in my opinion. But also we have to strengthen the civil society themselves by having more network, so we can support each other, um, and also support each other in terms of, whenever somebody is threatened by law enforcement agency, then the others can immediately provide legal aid, for example. So that's also one of the actions that the civil society must do uh, to face the challenges. Uh, and then Mbak Giza, let me continue ya to question from Ahmad Miftah Farid
Okay.
about police reform. The police institution remains a powerful entity. What kind of reform that we can offer to the police institution? Well, there are many offers. There are many very good academic papers, policy agenda, policy recommendations, very concrete ones, are already put on the table. But the problem is, as you know, as we all understand, always the challenge to reform is always because those who benefit from the system obviously doesn't want any change, because then they will lose the benefit. So, but the main message in the reform agenda for the police is always to have checks against the power of the police. The fact is that there are many studies on this, so um, this is already academically presented everywhere. The problem is the problem in Indonesian police force is the fact that they have too much power. If you compare it to the police force in other countries, for example, only in Indonesia that the police does not only have the power on legal enforcement, but they even have administrative power to issue things like driver's license, which I experienced myself in other countries when I went to school abroad. Driver's license is not administered by the police. It's as administered by the local government or the state. I have my driver's license in the U.S. when I went to school there, and I had the test and payment and everything to the local authority, not the police. But in Indonesia, they issue driver's license, they issue the STNK, that's a tax system for the car ownership, not only car, any type of transportation ownership. Um, but having too much power is one thing. But the real problem in terms of rule of law is that every power has to be checked. Every power has to have the counterbalance. So it's not excessive. So it's not prone to the abuse of power. Now, the problem is our police force doesn't have that proper check. We do have National Police Commission, Kompolnas ya, Komisi Kepolisian Nasional, but that is not independent. Please do not forget that even by default, the head of the National Police Commission is the coordinating ministry of the politics and security. So, and then we also have internally, the police has the internal mechanism, but mostly for ethical conduct. But even if the ethical conduct is actions like torturing detainees, then instead of going to ordinary court, because it is a crime under our criminal code, instead they will only get, probably suspension, 3 months suspension, or removed from uh, a bigger station to a smaller station, and then in 2 years time, they will be back to their position. So the check is not effective enough. So the basic principle that we offer is to have more checks on the police and to reduce the power. So we really isolate the power of the police into the law enforcement agency, not too far, and also to connect the police with the society more. So that's the main principles. The details, there are many, like putting the police, for example, in one under one ministry, and it can be varied, I would say, but the main principle is to put more checks on the power. Do we still have time, Mbak Giza?
Yeah, we still have time for one
Okay.
question.
Okay. There's a question here about from Firna. The practice of autocratic legalism that occurred in the post-Jokowi era. Okay, thank you, because my research is indeed in Jokowi era, so it's an important question. And if you're interested, I also usually articles that I wrote, I put on my Instagram at Bivitri Susanti, and so if you want, you can also check. But it's all in Bahasa Indonesia. But I think there are also English versions of those articles if you search. But yeah, it's a good question because my research is mostly on the Joko Widodo's administration. After Jokowi, first of all, I would say that Prabowo, in my opinion, is the third term of Joko Widodo. Please do not ever forget that we still have his son in power as the deputy of Prabowo. And I would say that the only way that Prabowo can win, and this is not what I say, this is what Prabowo himself said 2 weeks ago in the anniversary of his party Gerindra. He was thankful to Jokowi. Hidup Jokowi, long live Jokowi, he said, right? So this is not what I say. It's what he himself admitted in the formal speech, that he won because of Jokowi. So he is the continuation of Jokowi, which means that he is using, or the administration, his administration is using the um, the framework and the practices and the methodology and the approaches used by Joko Widodo in terms of autocratic legalism. And this can be seen actually by the two laws that I mentioned before, because they were just recently passed, the revision of the mining law and the revision of the state-owned companies law that led to the establishment of Danantara, the holding company for the state-owned companies. So we can clearly see that in the two laws. But as I said before, law is not only about provisions in the statutes, but also about law enforcement agencies. And in that sense, we can see the practice in the case of the threat or pressure for Sukatani band using the police as law enforcement agency to shut, to make them quiet, even to apologize to the police. So just using these three examples, we can already see the continuation of autocratic legalism in Prabowo's era. Um, and for the, well, the Prabowo does gain benefit from Jokowi's autocratic legalism, but because now he can easily use the four analysis that I mentioned before during Joko Widodo. So Joko Widodo has successfully co-opted or weakened the House of Representatives, the Anti-Corruption Commission, the civil society, and the court. So now he can easily use those four institutions, uh, for his purposes. And he even adds more by especially using his leadership style, which is a militaristic style. Please don't forget that ever, that he is from the military. And I would say that we can clearly see how he's militarizing, if there's such English term, but let us use that term, the democratic process. Of course, we can see last week we just had a military camp for the democratically elected heads of the regions. Hundreds of them, have to use military exercises, although it doesn't have anything to do with public services. But also the ministers had to undergo that kind of exercise. So let us reflect that on the higher reflection. I mean, we don't only see those uh, those phenomena, those occasions as bits and pieces, as if we are looking at a infotainment, as if we are using them as a political gossips. But let's reflect that on the higher, um, how do you call it, higher analytical uh, kind of um, uh, thought, that we can really see how those bits and pieces on the militarization of the kepala daerah, of the heads of regional governments, the militarization of the ministries, at the end of the day, will also um, ruin the democracy, because then the model will be top-down kind of policy making instead of bottom-up policy making. So you know that rightly, in the military culture, there's no democracy. Rightly, I would say, because that's how the military should operate. But that's why it's incompatible with the democratic process in the democratic government. So they're not compatible, so they should not be put together. But now what we see is that they are put together. So this is even, I think, adding to the weight of democratic challenge. I mean, Joko Widodo is one thing. There's a very big democratic challenge during Joko Widodo's administration. But now I think we face even more challenges because of the top-down kind of policy making and governing. I mean, look at the example of the gas melon, the subsidized, how do you call it, household gas policy, which is probably we cannot term policy making if we really see the literatures on policy making, because apparently they didn't really, they didn't really consider uh, the potential effects and the mitigation to the potential effect and the monitoring and evaluation and all that is required in the policy, in the proper policy making process. No, they didn't. What happened was that, as we all know, there was the scarcity of the gas at some point, so people had to queue for that. One even passed away because she was too tired because of that, and that's actually the responsibility of the government. Uh, But what happened instead was that Prabowo himself became a hero by saying, "Stop this. I don't want this to happen. I don't want this to happen." So it was stopped, which is good for us, but that shows us how the top-down policy making is exercised. And that's not only an example which, and there are many more examples of the top-down kind of policy. Even for the makan bergizi gratis, for example, the free lunch provided by the government. Um, Prabowo wants that to happen, and the Ministry of Finance. It's not that she's innocent; she has a contribution to the whole problem of the free lunch. But we can see that there's the command from Prabowo as the president, and then although we have crisis, well, it's not really crisis, but we are approaching economic crisis. We don't have the budget, but as Prabowo ordered, then the Ministry of Finance and other ministries have to look for ways and justifications so what's commanded can be conducted. So this is the added weight that I mentioned before, which I think will make us, you know, we have to think more about the democracy in Indonesia. Okay, so there is only 10 minutes left, so I'm giving back the forum to Giza.
Okay, thank you. I think we should end question and answer session. Thank you very much for Ms. Bivitri for your answer. As we come to the end of our session, to all participants, you can fill the attendance list that appears on the chat rooms. Ms. Bivitri, before we close the session, can you give us some of closing statement?
Closing statement. Okay. Let me give you takeaways so you can have something to carry um, for next research or next projects that you will have. My takeaway is that probably just two takeaways. One is that law is easily used to cover up for declining democracy because of the legitimacy that it has. Because philosophically, law is something that has to be adhered by all citizens and all institutions without any exception. And that's really the coercive power of law. So it's a very perfect mask for declining democracy. And secondly, we have to analyze the use of law in authoritarian agenda by not only analyzing the lawmaking process, but also the law enforcement processes and agencies. So we can have a thorough analysis on how law is used for ruining or declining the democracy. That's all. I think. Thank you for your participation and hopefully interest. And I hope we still have more opportunity later on in different forums to chat a little bit more. Thank you, Mbak Giza, and the organizer, Fakultas Hukum Law Faculty of Universitas Muhammadiyah Surakarta. Terima kasih.
Okay, once again, I would like to say thank you for our speaker of this session, Ms. Bivitri, for the presentation. It's really insightful. We really appreciate it, and we hope that this session will improve our knowledge. Other than that, we also saying thank you to all of the participants that are already joining this session. And for a reminder, tomorrow we will have another session with different speakers. Lastly, I would like to say sorry if there is a lot of mistake. Once again, thank you so much. Wassalamualaikum warahmatullahi wabarakatuh. Okay, for Miss Bivitri, you can leave the Zoom meeting. Thank you.
Thank you. Terima kasih Mbak Bibip.